This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So you might remember that Matthew Storman got sued by Nintendo. This is the ROMUniverse lawsuit. And ROMUniverse, for best of my understanding, hosted a lot of Nintendo ROMs. And I believe you had like restricted downloading with a free account, but you could pay an amount of money and get unrestricted downloading. This is an interesting one because this is a form answer. This is not a traditional answer that you would see written by a represented party. You would not see a lawyer using this form unless it's required by the judge or by the court. This is a form. You can see here it's got blanks where he filled in Nintendo of America, filled in his name. This is going to look a little weird because it's in this form, and we'll go over it this way. So parties filing an answer to this complaint is Matthew Storman, and it has instructions here on separate pages. Write a short and plain statement. That's literally the federal rules of civil procedure. A pleading must be a short, plain statement of the answer to the allegations in the complaint. Number the paragraphs. The answer should correspond to each paragraph. Paragraph 1 of the answer corresponding to paragraph 1 of the complaint, etc. Then you have to state whether you admit the allegations, deny the allegations, lack sufficient knowledge to admit or deny, or admit certain parts but deny others, or lack sufficient knowledge to admit or deny the rest. So he writes, the court does not have jurisdiction over this matter because of liability immunity, and plaintiff has not claimed an ownership of website copies. What do I think he means there? I think he's talking about his claim that he's a provider, he's a service provider, and therefore he is in his safe harbor as long as he complies with the provisions of the DMCA, that notice and takedown and such. But there's more than just notice and takedown. And plaintiff has not claimed ownership of website copies. I don't know what that means. I'm pretty sure Nintendo knows what it owns and what it doesn't. And then the court does not have personal jurisdiction because defendant is not an individual but a service provider, ROMUniverse, who is not part of the required forum, like the location. The court does not have personal jurisdiction since service provider is protected under the DMCA and potential involvement of international actors. What? I don't know what potential involvement of international actors means legally. Plaintiff may have violated defendant's privacy rights by using unlawful means. Okay, I really don't know what he's talking about there. The venue is part of the forum, is part of personal jurisdiction. The venue is improper because owners of copies and plaintiff is a German agent, maybe international, and an issue of jurisdiction. Does anyone feel like we're channeling Edward Thomas Kennedy right now? The defendant was served, but the process, so this is like your motions to dismiss. These are like your basic defenses. The defendant was served, but the process, the service of process, the form of the summons was insufficient because it is not based on DMCA violations. Well, I don't think that's going to get him very far. Copyright infringement does not require a DMCA violation. The manner of serving the defendant with the summons and complaint was insufficient because it does not timely serve essential actors such as owners of copies, users, suppliers, distributors, copyright owners, and other Nintendo subsidiaries. Well, that's not going to change anything, but what he's actually trying to say is the required joinder of parties. He's saying that there are other parties who should be joined to the lawsuit, or else complete relief can't be granted. That doesn't make any sense. Yes, this is legal food salad. This is food salad. We're just saying words now. The complaint fails to state a claim, so that's 12b6. Complaints do not include any required DMCA violation or ownership of copies, fails to identify essential owners of copies. I think maybe what he's saying is that they should be suing the people who uploaded the content as opposed to the host of the content. I don't think that that's going to really change anything with the court. So another party needs to be joined. Does 1 to 10 for or against defendant needs to be joined in the case. The reason is that the plaintiff has failed to join the true and essential owners of the copies known only to plaintiff. What? Now that torpedoes my last thing I said. if they should have joined the people who uploaded, then what do they mean known only to plaintiff? ROMUniverse would be the ones who know who uploaded. Or unknown, he says here. And he didn't use this section. The plaintiff's claim for copyright infringement, trademark infringement, unfair competition, and unfair competition under the California Business and Professions Code is barred by accord and satisfaction, which would probably, if I recall correctly, accord and satisfaction is that they actually did perform under the contract as they were supposed to. An implied contract is an agreement which legitimately can be inferred from intentions of the parties as evidenced by circumstances and ordinary course of dealing and common understanding of men. Therefore, all actions of defendant are approved by plaintiff. So he's saying that Nintendo, through an implied contract, approved of what he was doing. There are two instances where an implied contract was established between defendant and plaintiff. Plaintiff has sent DMCA takedown requests over the last 10 years, implying that no further legal action would occur if defendant complied with the takedown requests. Defendant has complied with all DMCA takedown requests from plaintiff. What he's referring to there is called administrative exhaustion. An example would be if you want to sue your employer for an equal employment opportunity violation, you have to first go through an EEOC complaint, not a federal lawsuit. Only after you receive a yes or no from the EEOC do you have the right to pursue a federal lawsuit. I know this because I literally went through this process with one of my employers. And that is an administrative exhaustion requirement. You must go through the administrative procedure. You must exhaust your opportunities or legal rights through the administrative procedure, and then you can go file a lawsuit. Copyright has no such requirement. You don't have to file DMCA takedown requests in order to preserve your right to sue. Instead, you can go straight to a lawsuit. That's how these copyright trolls like Malibu Media and Strike 3 Holdings operate. They don't send DMCA takedown notices or give you a warning of some kind. They go straight to a copyright infringement lawsuit. Then it says plaintiff has allowed defendant for the last 10 years to list non-infringing material on the website in exchange for advertising material on the website by listing all of plaintiff's products to massive audiences who take mental impressions of plaintiff's brand and products, which are remembered and influence future purchases. It sounds like he's saying that if Nintendo gets free advertising, then you can pirate their stuff. And that's not a valid legal argument. That's not going to fly with a court. Arbitration and award. Defendant will petition to require arbitration to avoid increased damage to defendant. That's possible. That's an argument I'm going to be making in a case upcoming here, that there's an agreement between the parties and the agreement has a binding arbitration clause, and so the court should order the parties to go to arbitration. So what Matthew Storman needs to do there, not legal advice, but what Matthew Storman needs to do there is present what agreement he has with Nintendo that has a binding arbitration clause. And if it does, if that clause applies to these kinds of claims and these issues in this case, this activity, then yeah, he can ask the court to enforce a binding arbitration clause. That's actually the first valid legal argument he's made, but I don't think he actually has a valid binding arbitration clause in some kind of agreement with Nintendo. Just having played Nintendo games and agreeing to those terms of service, I don't think makes this alleged copyright infringement fall within a binding arbitration clause for playing the video game. But maybe he could convince a court that arbitration is the way to go. Oh, by the way, arbitration is not going to limit the damages or anything. It's just going to make it a non-court process. It'll be a court-like process through a private arbitrator. Assumption of the risk. For the previous 10 years, plaintiff continually allowed the defendant to operate the website and waited 10 years before filing civil action against defendant, thereby causing themselves greater and increased perceived damage. Assumption of the risk is like if you go buy a welder and you don't use it in in accordance with the instructions or with the proper technique of welding or something, and you hurt yourself, a defense for the person who sold you the welding equipment might be, hey, you assumed the risk of this dangerous activity of welding with high current and electricity and all that. But either way, you've assumed some kind of the risk. Like you undertook a dangerous activity knowing that you could get hurt. What he's saying here is, since he didn't get sued before, he should continue to be allowed to not get sued. That's, again, not a valid legal argument. The actual legal version of that one is there's a 3-year statute of limitations. So can Nintendo sue him for infringements that occurred more than 3 years ago under copyright, at least? Probably not. But the past 3 years of copyright infringement allegations are still going to be quite on the table and not taken off the table just because they didn't sue him before. It does not work like that. Contributory or comparative negligence. The plaintiff misrepresented the defendant's actions in direct violation of 512F, so he's saying that there's some kind of copyright misrepresentation here, and that Nintendo should be held liable for damages caused by plaintiff, including costs and attorney's fees. In a way, that's a valid argument. I think it's a completely failing argument here. But yes, 17 USC 512F does involve copyright misrepresentations, and if Nintendo made such a misrepresentation, they would be liable for the costs and attorney's fees and any actual damage for that misrepresentation. I, however, think this is completely failing because I don't see any misrepresentation here. They're saying that he hosts ROMs illegally. I don't think that's incorrect. I think that the ROMs are being hosted illegally. Duress, plaintiff brought this suit to put pressure on defendant to fear the negative out. I mean, at this point, he's just filling in the blanks. Like, he's seeing an affirmative defense and he's just, filling in the blanks here. So yeah, word salad. Plaintiff brought this civil suit to put pressure on defendant to fear the negative outcome, including fines, penalties, and to relinquish defendant's valuable website to plaintiff, which appears to be the goal of the civil suit. Its value could be multi-million dollars to plaintiff. Yeah, I don't think that puts him under duress. So let me explain. We're in the affirmative defenses section here. Affirmative defenses mean, yeah, I did it, but here's a reason why I'm not liable. Affirmative defense of duress would be me, like I signed this contract under pressure, under a specific kind of pressure that's recognized by the law, like being held at gunpoint, under threat of violence or something. We made you sign this contract. That's duress, not we brought a civil suit and therefore your previous actions that we're suing you for, it would be the previous actions would have to have been made under duress. So did Nintendo pressure him to host the content under threat of some kind, usually threat of violence? No. So that's not going to be duress. Estoppel. Plaintiff implied contract with defendant for 10 years is unilaterally violated by plaintiff where plaintiff received valuable advertising. This is not estoppel. And massive positive exposure without notice or negotiations for mutual advantage, nor making offer to purchase defendant's assets. Plaintiff breached the contract, therefore injuring defendant. No, that's not really estoppel. Estoppel is like a reliance, like I relied on your representation that you wouldn't sue me, and that's the only reason I was hosting this, even though I know it's illegal, because you said that I could in some way, and I relied on that. So a clearer example of estoppel or detrimental reliance would be, I promise you that I'm going to give you $1,000 for your graduation. And before I give you the $1,000, you go and take out $1,000 loan to buy a car or something, thinking that you're getting $1,000 and you can immediately pay the loan back. So you relied on my promise. Normally, promises are not contracts. A unilateral promise is not a contract. A promise to perform, a promise to pay money has to be supported by a mere peppercorn of consideration, meaning you have to have promised something in return or given money in return. There has to be some value to the bargain of the parties in both directions for a contract to be made. So a promise can become a relied upon promise if you had every reason to believe that I was going to give you the money, and then you went and took out a loan, or you got that apartment or something that I said I'd pay for your apartment, so you went and got an apartment, and then I said, I didn't mean it. Well, you already incurred damages, so you could probably say something about detrimental reliance or estoppel. Again, this is not that. Failure of consideration. Plaintiff is required under DMCA to send proper notification of alleged copyright infringement to defendant, requesting defendant to take down alleged infringement material. No, they are not required to do that. The fact that they've been doing it has been because they were only a little bit annoyed at you, and then they got really annoyed at you and decided to file a lawsuit. So no, there is no administrative exhaustion requirement, and that's also not failure of consideration. Failure of consideration is what I just said. You have to have a two-way consideration. Contracts have to be mutually, it has to be a mutual promise or a promise in two directions, or performance in one direction and promise to pay in the other or something. There has to be a basis. It can't just be a one-way promise, none of which exists here, in my opinion. Fraud. Plaintiff in complaint failed to mention the defendant's DMCA rights to send takedown notices to defendant. Plaintiff's claims are fraudulent for this admission and waste the court's... No. I think it's Matthew Storman that is wasting the court's time with this answer. But okay, he's pro se, I think. And that makes sense that he's trying the shotgun theory, or the spaghetti at the wall theory, or the word salad theory of defense. I get it. On some level, we all do it, but lawyers just do it in a more refined sense. You know, you make all the claims, you make all the defenses. Maybe we wouldn't be making all of these tenuous or frivolous defenses. But no, it's not fraudulent to not send DMCA takedown notices, as I'm getting to be a broken record about here. Illegality. Plaintiff misrepresented the defendant's action in violation of 17 U.S.C. 512F, which is the misrepresentation part, and should be held liable for damages. No, illegality as an affirmative defense is that the contract between the parties, the subject of the contract was illegal. So there are certain things you can't contract for. You cannot contract with someone for the commission of a crime. You cannot contract with someone to have intimate relations. Those are not valid objects of contract, and so illegality would be a valid defense to that. Injury by fellow employee. He actually didn't fill that one in. Amazing. Latches, as in delay. They waited too long, and there's some... Latches is not a defense to copyright infringement. Copyright infringement has a 3-year statute of limitations, so the latches defense is the 3-year statute of limitations. That's it. License. Plaintiff granted an implied license and contract during the last 10 years to store potentially infringing material on the defendant website. He's got to show the license or show the implied license and where it came from. Just, we didn't take you down before is not an implied license. Sorry. Payment. Plaintiff received payment in the form of massive brand exposure. Really, choosing beggar? You're saying that I can give you lots of exposure. I don't have to pay you. Yeah, not. That's not how that works. Release. Plaintiff, by action or lack of action, agreed not to hold defendant responsible. Well, you got to show the agreement. You got to show the release. Res judicata. Defendant or potential attorney will research relevant laws. Okay. You have to name the affirmative defenses here and give the short, plain statement of how they apply. So that's just a waiver of res judicata. What is res judicata? That's a double jeopardy kind of thing. The claims have been adjudicated before. These claims have not been adjudicated before. If they have, point to it. He won't be able to, I don't think. Statute of frauds. Again, will relevant research relevant laws. Statute of frauds is not, I think, applicable here in any way. Statute of frauds is like any transaction over $500 has to be in writing. So if I buy something from you what's worth more than $500. And this is, again, not legal advice that varies from place to place. But like, if I contract with you to pay you $500 and you're going to work on my house, well, it's supposed to be in writing. So a defense might be statute of frauds. You didn't put the necessary contract in writing. Finally, a statute of limitations defense. Plaintiffs stated in their complaint that they have known about ROMUniverse for 10 years. The copyright law under 507B states that no civil action shall be maintained under the provisions of this title unless it is commenced within 3 years after the claim accrued. Yes, if Matthew Storman had stopped running ROMUniverse 3 years and 1 day ago, or maybe even 3 years, I don't know exactly where the line is there, then yes, he would be safe and outside of the statute of limitations for copyright. Continuous violations are continuous accruals, are continuous availability of claims. If I'm committing copyright infringement over the last 4 years, well, maybe you can't sue me for the lattermost year, but you can still sue me for the 3 years in between. Waiver, plaintiff's German representative continues to send DMCA takedowns to defendant, implying that no legal action will occur if defendant complies with the takedown requests. No, the DMCA, even complying with a DMCA takedown doesn't mean that you're free of copyright infringement. It means that if you were otherwise free of copyright infringement, you can remain in your safe harbor. And that's for user-generated stuff. So he's going to be pointing to how the user-generated content on his website is immediately taken down upon sending a takedown notice. And so he can continue to host content as long as there's other requirements, though, as we saw from Nintendo responding to his motion to dismiss. I think it was his motion to dismiss. Defendant is a service provider and the sole owner of NDS Universe and ROMUniverse. Defendant shall not be liable for monetary, statutory, injunctive, whatever relief. And yeah, that's his best defense, is that he's a service provider. I think it's a failing defense because there are other requirements to being a service provider. But yeah, his defense is going to be that he didn't know that any of this content was infringing or that it was even there on his platform. He didn't curate it. He didn't make money in an illegal way off of it. If that's all true and provable in court, then yeah, he'll have a valid defense under the DMCA safe harbor provisions. He cites other copyright law exceptions, provide protection, fair use. In no way is this fair use. First sale. In no way is this first sale. Implied contract, I don't see any such implied contract. Exceptions under the DMCA, fine. That's his best defense, I think. And equal protection due process. No. Equal protection of the laws means the laws apply equally to everybody. Due process means you get your day in court and it's a meaningful court experience. He's having a meaningful court experience here. There's no violation of equal protection or due process. So what else has he written here? Because we're only halfway through this. Defendant misrepresented their copyright, trademark, and unfair competition claims. Nintendo's German representative has acted contrary to Nintendo. No. And he is a party without an attorney here. And so he goes into the answer and defenses. Defendant denies the allegations of the copyright infringement or piracy, denies the allegations of trademark infringement, denies allegations of unfair competition. No, those are the counts. Those are the claims. Those are conclusions. That he doesn't have to answer those. He doesn't have to deny those. Again, not legal advice. Any trademarks only exist as online data. I have no idea what that means. Defendant provides non-members and members full access rights. Defendant also provides increased bandwidth for premium member. Defendant makes no direct profit from copies uploaded or downloaded. Okay, if he can prove that, great. So he says that he is an online service provider under the DMCA. That's probably his best defense. Defendant provides copyright owners access to all files that are arranged by uploaded title only. So he's saying that because the titles are there, then they should be able to find them and issue takedown notices. I don't know if that's going to reach a level of protection under the safe harbor provisions of the DMCA. Again, cites this implied contract with Nintendo. Nintendo has full access to all content to locate potentially infringing material, and Nintendo receives unlimited advertising. I don't think it works that way. I don't think Nintendo wanted advertising or contracted with you for advertising. Defendant is unaware of the content. So that, again, I think he's wrong about that. I think he's completely aware of the content. I mean, it's literally called ROMUniverse.com. But if he is unaware of the content, then yes, that would help him fall under the safe harbor provisions. And he says that Nintendo can request removal at any time through the DMCA. Defendant is unaware of any infringing material that is uploaded to its website. Sure, I don't buy it, but okay. This material may be owned and disposed of by the first sale purchaser. No, the first sale purchaser does not have the right to extract the ROM from the cartridge or from the digital download and then put it on another website. So that's first sale is just not even close to applicable. Defendant is not responsible for any illegal downloading or uploading by users. We shall see. All website data is digital data. This includes copyright, trademarks. That doesn't change anything. There are no physical games. That doesn't change anything. Data requires a capable and proper device to fully translate and display the data. That doesn't change anything. We literally just saw that when we were going over the thing dropping out of the plane, the camera dropping out of the plane, that it doesn't matter if copyright's in a digital medium, it's still a copyright. It is part of an implied contract over the last 10 years. I don't think so. I don't think he's going to be able to point to any implied contract. And so he goes through his answer. This is the actual answer. He denies allegations of piracy. They fail to join other parties or name subsidiaries, name distributors. I don't think they have to do that. Defendant is a service provider, and defendant has no John Does working in active concert, so there's no other people, he's saying. Defendant denies allegations that they store, categorize, reproduce unauthorized copies of Nintendo video games. I think that's exactly what they do, is store, categorize, reproduce unauthorized copies of Nintendo video games. And they say they receive no direct income from such. I also don't agree with that. So it says that there's no visible serial numbers. I have no idea what that means. My best guess is that he's saying they don't watermark their copies. How would you watermark the copies? Like someone extracts it from a ROM and that's somehow going to get a watermark in the process? I don't think so. Nintendo fails to keep or make known a master copy. What? No idea what he means there. Nintendo does not encrypt its data. Are you kidding me? I think that Nintendo probably does encrypt their data, and even if they don't, failing to encrypt your data does not eliminate a copyright infringement claim. It maybe eliminates a Section 1201 circumvention of technological protection measures claim. Nintendo delivers its product over the internet where it is very vulnerable. Assumption of the risk. I call that BS. Nintendo could easily deliver only serialized hard copies and maintain records of purchases. No, they're allowed to distribute digital copies. Nintendo's 10 million users, each of which may have 20 games over their lifetime. This estimate approaches 1 billion games sold per item 25. 80% of users are non-US buyers. 8 million. This is a jurisdictional issue because people buy Nintendo games. Okay. Now, here's the thing about an answer. He's answering their complaint. So in order to go over the rest of these, we probably have to go to their complaint and look at the mirror image claim versus his answer. But instead, I'm not going to do that. We're just going to skim through this real quick. There's only 2 pages left. Nintendo implies legal copies are also a problem for Nintendo. They could make technological measures and digital rights management, which I think they have. Like, I don't know that it's that easy to just go rip your ROMs off of a cartridge without having circumvented some kind of technological protection measure along the way. So they say Nintendo fails to watermark the pirated copies. He's again saying that he's an online service provider and not a he. Nintendo fails to provide names of other targeted websites and internet traffic data. I'm assuming that he means that they didn't sue other people. They actually do, but I think ROMUniverse was one of the last ones. Nintendo has profited from free advertising that changes nothing. This may be an entrapment violation. Entrapment is a criminal thing. It's a defense to a criminal charge that you wouldn't have committed the criminal offense except for the police officer coercing you into it. undercover officer walks up to you and says, "Hey, I need you to help me out. If you could just go over there and pick up that bottle of juice that I claim that I bought from the store and bring it over here to me, that'd be great." And you go over and do that, and it turns out that it wasn't purchased. That's probably some kind of entrapment defense. You wouldn't normally commit a crime of stealing from a store, and the guy made you think that you were doing the right thing because he couldn't or something, and so you went and accidentally, mistakenly stole a bottle of juice from the store and brought it back over. Well, that would be a theft or conversion offense, petty theft of some kind or something. And that would be an offense under the criminal law if you had done that for a civilian. But let's say that you did it for a cop. That would be an entrapment defense. I paraphrasing, but that's my understanding of entrapment. Material on defendant's website is a substantial advertisement. Yeah, we got that already. There's no limitation on visible keywords, so Nintendo can find any infringing content easily and then send a takedown notice. The website offers a list of non-infringing material, and Plaintiff's Exhibit A lists copies of non-infringing. Okay, so if what non-infringing material is non-infringing, but he's going to have to show how it's non-infringing. Visitors use search to locate non-infringing material. This facilitates copyright owners in locating potentially infringing material, so they can send a takedown notice, and he claims that he timely responds to takedown notices. Great. If he does timely respond to takedown notices, then that will keep him in his safe harbor as long as he's also complying with all the other requirements of the safe harbor. And if he's actually doing all of that, then that will limit his liability for some or all of the applicable infringements. He says there are no pirated games. I don't agree, but that's just my opinion. And he continues with they can find infringements. Nintendo must have shown some download numbers, and he's saying that those are incorrect download numbers. I'm not sure how that's going to play out. He's going to have to show that the numbers on his website are fake. Okay, but that still gives rise to Nintendo's belief. Information and belief is a sufficient pleading. Is a sufficient basis for pleading copyright infringement claims, are that you said you were committing copyright infringement. Here are the numbers. That's sufficient to get into court and stay in court and get to discovery of evidence, which now happens that he's answered. Let's see more. In non-infringing copies, popularity of website is due to Nintendo advertising on website. Really? Do you think Nintendo advertises on ROMUniverse.com? I don't think so. I don't think so. But maybe Nintendo advertises on ROMUniverse. Defendant incorporates by reference its responses to the preceding paragraphs. Not liable. NOAA has not provided. Nintendo of America. That's what that is. Nintendo of America has not provided that the download files belong to them. Really? You think that they don't own the copyright for the games that they claim that they own? You think that Nintendo would just go claim somebody else's games? I think what he's saying is that the first sale doctrine applies, which it does not. Go back to the first ROMUniverse video that we made and Larry from Redigi and all that. Digital copies are not valid for a first sale defense. That's not how that works. The website does not house any pirated works. I seriously doubt that. Defendant does not reproduce, distribute, or publicly perform or display unauthorized copies. Defendant completely and wholly complies. I think what he's doing here is responding to their counts. These are going to be their counts. The digital structure and content of the files is not known to defendant. They may require downloading to a proper device. Defendant does not download nor possess such devices. No games are sold on the website, nor are visitors encouraged to download and play. Defendant's actions are not misleading, etc. He doesn't, in an answer, you don't really need to address their actual claims or counts of copyright infringement, direct infringement, contributory infringement. Those are going to be more or less conclusory, and you can say that these are, you can basically deny those categorically. Again, not legal advice. I'm not looking at the specific thing he's answering. Maybe there is some kind of factual claim in there that he needs to deny an allegation. And then again, defendant incorporates by reference. Defendant denies engaging in unlawful business. But yeah, he's answering the unlawful business practices count now. I think he's going to lose this lawsuit big time. I'm sorry that's what's going to happen, but that's I don't think that he's got very good legal defenses here at all. His best defense is the safe harbor of the DMCA, and I'm not sure that he's actually complied with the safe harbor provisions. And he will have to now enter the discovery stage. The court will order a pretrial conference. There will be initial disclosures, required disclosures of evidence and things. Nintendo will issue discovery requests to him, likely including a request for a deposition. They automatically have the right to depose him. He'll have to know how to object to the interview that is the deposition, how to object to each question that he doesn't like and things. And Nintendo will very likely be able to gather evidence through the civil discovery process. The discovery process allows them to demand and receive all relevant documents, things, and testimony. Relevancy is anything that makes their claims or his defenses more likely to be true or less likely to be true. So that means he'll be required to turn over business records. He'll be required to admit or deny things in a request for admission. He'll be required to answer written questions in a request for interrogatories. He'll be required to produce data, drives, things like that in a request for production. And he will need to attend a formal interview under oath and on the record, at least on the record of a transcript that can be later used in court, in a request for deposition. So he's got a lot going on right now. I don't feel, I feel pretty bad for him. I don't feel like his defenses are going to be very good here. And I don't know how he would be able to get out of this clean in really any way. So yeah, let us know what you think of that in the comments below. Again, I know a lot of people like their ROM sites, and I know that there are a lot of people who are fans of piracy. Even I, back in the day, before becoming a copyright attorney, learned how to use Photoshop by using a pirated copy of Photoshop, or downloaded videos that I liked, or episodes of Mythbusters and things. I can confidently say that out loud, admit that now, because that was well over 3 years ago, and I am not using any pirated content now to this day or anything. I now pay for all of my content that I consume, Hulu and Netflix, and I buy material on Google Play Movies and TV shows and things. So I can confidently say that I'm not a pirate anymore. I may own the domain piratelawyer.com, but I just mean that I represent people who are accused of piracy. But so I'm no stranger, and I'm certainly not above having committed piracy in the past. So I don't want to speak down to anyone, but it is copyright infringement. It is piracy. It is probably some kind of unlawful business practice or something like that. So I don't think Matthew Storman is going to come even close to winning this lawsuit. And I don't know how he's going to get out of it, because these are going to be statutory damages that might be above and beyond the profits that he's received. And many times people receive profits and they spend those profits too. So if he's even made several $100,000, that might not be enough to overcome the demands of the plaintiff. So Nintendo might be getting a rather large judgment. I think we called it a $1 billion copyright lawsuit because if the numbers really add up and there really are that number of infringements, it could very well be $150,000 maximum damages for willful copyright infringement per infringement. And that doesn't need to, there don't need to be that many infringements. I mean, what's $1 billion divided by 150,000? There only needs to be 6,667 infringements to reach $1 billion at that level. And there's probably way more than 6,000 and 7,000 infringements on ROMUniverse.com. So he's really got to be relying on the safe harbor. He'd better have all of his ducks in a row for that one, or else I think he's sunk. I don't know how anybody comes back from that. Civil judgment for copyright infringement. You're gonna be declaring bankruptcy on that. And again, not legal advice, because my understanding is that courts don't always agree that bankruptcy applies to willful copyright infringement, which often falls under willful torts. And willful torts or legal wrongdoing isn't dischargeable by bankruptcy. You can't get out of your willful tortious act by declaring bankruptcy. It's possible there's some wiggle room in there. Let me be completely fair. I've read a case or two where there was a way, but it had special elements to it that made the willful act somehow disconnected from the prohibitions from getting that discharged in bankruptcy law. How about faking your death? Well, I mean, I wouldn't recommend it, but yeah, at this point, like I don't think there's any way out of this lawsuit for him. I feel kind of bad for him because there is no way out, but I don't mean bad as in the sense that like someone who breaks the law shouldn't be held to account for it. I just mean like he's going to be held to account for it, and unless Nintendo makes a deal with him or something. I mean, maybe that's the way out. Maybe the way out is that he makes a deal with Nintendo. All right, everybody, thank you for joining me. That is our show. I really appreciate your support and the community that we've created here, and this is a beautiful thing we've got going with Lawful Masses. Please consider helping us continue our mission of fun and educational legal stories and news for you on a daily basis. Brought to you by me, Leonard French, your Lawful Masses host. Please consider supporting us on sponsors.com/law or patreon.com/ljfrench. These people have supported us in the month of February at the $50 or more level. Aspernari, Video Demonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Cute Grills in Your Area, Ottah, Kysal, and Longreach Jones. I really appreciate all your support, and there will be $5 plus supporters scrolling on the screen in front of me. I'll see if I can put some dog video on the outro here, as we've got dogs now that I'm back in the States, and I look forward to seeing all of you in the videos that drop. Remember to subscribe on YouTube, click the bell to get all your notifications of our daily videos, and I will see you there. Love you all. I'm Leonard French, your favorite copyright attorney. Have a good one. Bye. Right, so my folks picked up Nico. Let's see what he looks like.
This feels so like oh, look, your hair is all short. Your hair is still flowing, but look at how short it is. Oh, and you've got a bow tie. Oh, you've got a tie on. Oh, how cute is that? And how cute is that? Are you feeling all happy? Happy that you're not caged up in the loud place anymore? But you look wonderful. You look wonderful. You do.